Lanisha Taylor, Mr. Carter. All right, so we're on the record in. So we're on the record in docket 24-00945. That is people of the state of Michigan versus Lanisha Taylor. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Carter.
And please the court, David B. Carter Jr. on behalf of Ms. Taylor, who is present standing at council table.
And ma'am, you are Lanisha Taylor, is that correct?
Yes, Ron.
All right, thank you. This is the time set for final pretrial today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I don't believe I have witnesses here today.
All right. So people are unable to proceed?
I believe so, yeah.
Mr. Carter, response.
I'd ask for a dismissal at this time.
So Ms. Taylor, I'm going to be in possession of a dismissal without prejudice based on your request or your attorney's request, which means that the people could reissue this charge if they choose to, but realistically today the case will be dismissed. All right, ma'am?
Thank you.
All right, let me sign that. Might take some printing time.
No problem.
All right, I'm in possession of a nollie pros or order of dismissal on 24-00945. I will sign that accordingly. So the case is dismissed today for our purposes. Anything else for the record in 24-00945? Ms. Wilson.
Not for the people.
Mr. Carter.
Not for the defense.
All right, Ms. Taylor, you're all set. Thank you for your appearance today.
Thank you.
Good to see you, Mr. Carter.
Thank you. But I'm here on another case.
Are you really?
Paper.
That's good news. You're here in Cottenham?
Yeah, is that him? It looks like it may be.
It's Cole, Hernandez, and Williams are the people I have up there.
No, the one that is walking.
No, that's Cole.
That's
Okay.
Michael Cole. All right, Ms. Wilson?
I believe we're ready on Kirkus.
Kurgis?
Yes, I believe she has 2 files.
All right, so we're on the record in docket 23-02845 and 23-02846. That is people of the state of Michigan versus Andrea Kurgis. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender, on behalf of Ms. Kurgis, who is present standing to my right.
And ma'am, you are Andrea Kurgis, is that correct? All right, thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I was provided with dog licenses for both dogs this morning, so the people will be moving to dismiss on both files for compliance.
And I think they're both tickets.
They are, yeah.
Okay. All right, Ms. Kurgis, both of these files are going to be dismissed without prejudice, which means the people could reissue if they choose to, but realistically, both files are dismissed for compliance purposes. All right, ma'am? Anything else for the record on either one of these files, 23-02846 or 23-02845, Ms. Wilson?
Not for the people.
Ms. Wicks?
No, thank you.
All right, Ms. Kurgis, you're all set. Thank you for your appearance today.
Yes.
And then did Ms. Wicks or Mr. Lee, did you need to meet with Ms. Hernandez, Mr. Cole, or Mr. Williams?
Ms. Hernandez should be good. I've got the license for her, so.
All right, let's,
If I could be put in a breakout room with Mr. Williams, though.
all right. So when you join in, we'll put you in I'll put you in a breakout.
Thanks.
Or you'll be put in a breakout room.
I can do this. It's LT.
It's LT day.
I get so confused.
You want to call Hernandez?
Yeah, let's do that.
All right, Ms. Hernandez, we'll call your case. So
Good
we're on
morning.
the record in docket 24-01229. That is people of the state of Michigan versus Spontanea Hernandez. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Hernandez. Are you here on that case, Mr.?
I am Assistant Public Defender John Lee on behalf of Spontanea Hernandez.
And ma'am, you are Spontanea Hernandez, is that correct?
That is correct.
All right. And you can hear me all right, Ms. Hernandez?
I can.
All right, thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I did receive a dog license through Mr. Lee this morning, so the people will be moving to dismiss for compliance.
All right, that's a fair statement, Mr. Lee.
Yes, sir.
And this is on a ticket?
It should be.
I think it is. Yep. All right, Ms. Hernandez, this case is dismissed without prejudice, which means that people could reissue if they choose to, but realistically, for our purposes today, the case is dismissed. All right, ma'am?
Sounds good. Thank you.
Thank you. You're all set, Ms. Hernandez. Have a nice day.
You too.
And if you want to do Beasley, he is your pro per.
Mr. Beasley? All right, so we're on the record in docket 24-01095. That is people of the state of Michigan versus Johnny Beasley. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
And sir, you are Johnny Beasley, is that correct? All right, and Mr. Beasley, you are not represented by counsel today, is that correct? All right, thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. If the court recalls, we had adjourned previously so that I could figure out what my office needed in order to provide Mr. Beasley with discovery. I did learn that we needed an appearance and I was provided with a scale form for an appearance. However, Ms. Holden pointed out to me this morning that there is no box for a per person. There's only a box for attorneys. So I guess I'm at a bit of a loss again.
I would think that if he writes his name in pro per and doesn't check the attorney box,
Boxes?
yeah,
Okay, all right.
we should be good to go.
That would be sufficient.
And
for
then you
me.
can provide discovery.
Yeah, and that would need to be filed with the clerk and sent to our office.
All right, so Mr. Beasley, since you're representing yourself, in order to give you discovery, you're gonna have to file an appearance and you're gonna have to file it with the criminal clerk. And then that'll work its chain down to the court file and to the prosecutor file, and then they can provide discovery. It's really a protection of you because they don't want to give your information out to anybody who asks for it. So if you fill out that form and provide it to the criminal clerk, I'm assuming if you will go to the window, you should be all right.
Yeah.
All right. If you just go to the window and make sure you sign that, make sure it's all filled out. I think it's just a matter of captions.
Yep.
And then your name on make sure you put pro per by your name, which would indicate that you're representing yourself.
Okay.
All right.
And then if we just want to set this for another pre-trial?
Yeah, I think that's probably the thing to do, is to set it out so you get all the discovery.
Yes, sir, because I was looking for it this morning. I couldn't even find it.
Yeah. And I think if I remember correctly, it's a protection. They don't want to give that property out to anybody.
Okay,
They want to make sure you get the property.
all right.
So, or any, and they don't want to give it out to anybody who says they're, which is a kind of a big deal.
All right.
Okay, so we'll reset for pretrial. And 2 to 3 weeks?
Yeah.
Whenever we have the next Monday that we have.
June 24th at 9.
All right. So it'll be June 24th at 9 a.m. So, Mr. Beasley, if you fill that and you get it to the clerk, it'll work its way to the court file and the prosecutor's office, And that'll give them time to get you all the discovery needed in the matter, all right? And then we've reset it for June 24th at 9 o'clock. You should get notice from the court officer for the June 24th at 9 o'clock date. Anything else for the record in 24-01095, Ms. Wilson?
Not for the people.
Mr. Beasley, do you have any questions of me?
No, not right
They can, if you fill that out and provide it to the counter, if they don't have everything filled out, they'll tell you, and then you can, that'll be like a plan. Then you can tell you, you can
now.
fix
Like,
it.
appearance today, like court paper today to come back.
Yes, you should get one from the court officer, a notification for June 24th.
I'm having trouble scheduling. I need to bring it to the office.
All right.
There.
So we're getting a technological error. Normally, you would have gotten notice. If you have a seat, we'll make sure we get it. We just got to print it out.
And Mr. Cole to my breakout room.
Yes.
Thank you.
So Mr. Cole.
Yes.
All right. So Mr. Cole, you're gonna get a prompt to go to room 1.
Yeah. So we were trying to get a CPS product out. They should have been sent to. Yeah.
So you don't know if you can get that.
I should have, my understanding is, it was from Red
So-
It's gone. And it's 2015. I don't even think I have my doctors around anymore.
Okay, I was saying, because I thought that's what I read too, was
Yeah.
that he had adopted the child out, so
Yeah,
he's not.
so the
there's-
kids, yeah,
Okay.
so,
You want to dismiss this? Civil infraction?
I'm more inclined to set it for final pre-trial and dismiss it when my doctor doesn't show.
Yeah, okay,
Because that's not.
yeah, sure, that's fine.
You want to call a case? There's a gentleman back there too. What's your name,
Yes,
sir?
I
Mr. Goodman. Mr. Goodman.
don't think Mr. Hull is here yet.
No, I
All right.
haven't seen.
He has appeared by Zoom previously.
It's Kenneth.
Yes.
All right. We're waiting for
It's just a different sentencing.
for the lawyer, I think.
So I think it's just. That's what I thought.
Okay, so it's a link.
Right, yeah.
He said he did. so-
Okay, I think he went and got paperwork for
Okay,
it.
okay,
So.
okay.
So we're waiting on that lawyer.
Well, I think Mr. Lee's stepping in for Mr. Goodman.
Oh, okay.
Yeah.
Yes. Mr. Goodman?
Yes.
All right. And then who's the doctor one?
Mr. Hall, Alexander Hall, that's the 2015 case.
Oh, well, that I remember that case.
Yep.
Do you need this back?
Yes, please.
All right. So if we're waiting on that, if Mr. Beasley's just waiting, I can write it down for him.
I got it to do something.
All right.
Can you send it in the mail?
We're seeing, she's trying a backdoor way to print it. There we go. I heard it. Yeah, Mr. Hall's the 2015 case.
Yep.
So you're gonna set that final pre-trial and then, so
One mail to.
Ms. Wilson, you're 27.
Yes. I said that at case review the other day, somebody mentioned somebody had a charge from 1997. I said, oh, that's the year I was born, and everybody.
like everybody's still-
collectively
yeah,
groaned.
groaned.
I was like.
Yeah. That used to be my claim to fame, but it's not anymore. But I had tried my first case at 26. But now everybody's tried their first case at 26. Everybody, that's just the thing now.
Yep, they just kind of throw you in.
Yeah,
Yep.
just kind of, you know. saw Mr. Marks had but his service is in Detroit.
You know, I was in trial last week. So I meant to check it on Friday. I checked it on Wednesdays and Thursday during breaks and I didn't see anything.
Yeah,
So
I brought it up last night. It's still in Detroit.
it must have.
Sunday night. I checked it yesterday. Just because I'd known him for so long,
Yeah.
you know, I
It
mean,
was very.
we kind of grew up, all of us kind of were at the same level.
Yeah, I'm still shocked. I mean,
Me too. Me too.
I'm gonna, because of that, I'm gonna go and get my arteries checked. Seriously, I am.
Well, you know,
I just had a doctor's appointment.
I
And he
know.
says, do you want to get these tests done? You don't have to. I'm like, yeah.
but Mr. Samoris is the worst to talk to, by the way, because he's all our age and
Yeah.
he grew up. And I go to Mr. Samoris, I'm like, you know, Ken Mark just passed, and Samoris is like, you know, we're all in that alley right now. We're all in that. We're in a heart attack alley. I'm
Yeah,
like,
I'm like-
Pete, why don't you shut up?
Yeah.
Okay? Stop talking, Pete. Okay, like just because you don't have to say the obvious.
I know.
No, so, but yeah, we're all the same. I mean, that's
He's a funny guy.
he is a funny guy. I've known
He
him for years and
he
years.
can talk about anything for a long time.
Yes, yes, he can. Yes, he can. I went to law school with him.
Oh, you
Yeah,
did?
he was about a year and a half. Him and Crino were a year and a half ahead of me. But that's when I first met him and his ex-wife
Yeah.
in law school. He's been a long time, pretty good friend that we've had breaks, because there were times where I put everything in writing. And I told him, like, we're not going to talk about the case. I'm just putting it in writing.
Yeah.
Yeah.
And when you accuse me of coaching a witness on the stand while the witness is there, we're going to be in writing for about 6 months.
Yeah.
And he's like, okay. And then we're done for 6 months and we're all done.
He can really.
Yeah, he's quick.
Yeah.
Quick on the trigger. Yeah. He's a good friend.
We're ready on Goodman.
All right. Mr. Goodman, you can come up here. All right, and Mr. Lee, you're standing in on this case?
Yes, I'm standing in for Lauren Sutter.
All right, thank you. So we're on the record in docket 23-01362. That is People of the State of Michigan versus Kenneth Goodman. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Kenneth Goodman.
And sir, you are Kenneth Goodman, is that correct?
Yes, sir.
All right, thank you. This is the time set for I have it as a deferred sentence. Ms. Wilson, how we proceeding?
Thank you, Your Honor. Yes, this was a plea back in June of 2023 to a dog at large. And the agreement was that upon successful payment of restitution, it would be dismissed. I am in receipt of the restitution amount. The balance is currently 0. So I believe the terms of the agreement have been met.
So this is this on a ticket?
Yes.
Yeah, I have all three. I have the counts on a ticket.
Yep.
All right. So, Mr. Lee, is that a fair statement? I'll write for the register of actions that we've had the deferred sentence. All conditions were met and the case is dismissed.
Yes, Your Honor.
All right. So, deferred sentence. Held. All terms were met. Dismissed without prejudice.
Phone call.
Can't be lost. All right, so Mr. Goodman, all terms of the deferred sentence were met, and so this is dismissed without prejudice, which is the usual format. Okay, It's dismissed without prejudice from the ticket, and you should be all set, all right?
All right,
That should take care of it. You're free to leave.
thank you. Have a good day.
You too, thank you. And thank you for stepping in on that, Mr. Lee.
Absolutely.
Did we want to go on?
Yep.
You talk to Cole.
Yes.
Okay, what are we doing? on
So we got these.
Okay,
Maybe is here.
okay, okay, right.
Find a way to print that.
For whatever reason, it's not showing up in actual calendar, we can print it, so I printed how to make it, Kelly's got a pack jacket, so she's
Okay.
Kelly things. Not okay.
Finding ways to get things printed.
Yes.
All right.
That works.
Okay.
It is.
Yes.
There are so many aspects to the job description here, and they all have to do with technology.
You can't see it, so like, we don't know if we're double booking anything.
I know, I
It's the
know.
worst part, because right now we really can't see it, and that's, yeah.
It's gonna be a part of every job description from now on. It's going to be like, the applicant must be sophisticated in technology. You know, because it's just every facet of life
I
now.
feel like 2024, pretty much most job descriptions have that.
Maybe for your job
Yeah,
description.
maybe, yeah.
My job descriptions, when we took like 138 classes online over COVID. And
Yeah.
you could hear people screaming.
Yeah.
You could hear the yelling going on as the over 50 crowd was like, what?
Yeah.
What are we doing? You know, so yeah, it's just the way it is. Miss Wilson, what are we on next?
I think we're ready on Williams.
All right, so Mr. Williams, we'll call your case. So we're on the record in docket 24-00548. That is people of the state of Michigan versus Michael Lynn Williams. Will the parties please introduce themselves for the record? Miss Wilson.
Abigail Wilson for the people.
Miss Wicks.
Heather Wicks, Assistant Public Defender on behalf of Mr. Williams, who is present via the Zoom application.
And sir, you are Michael Williams, is that correct?
Yes, sir.
All right, and you can hear me all right, Mr. Williams?
Yes, sir.
Thank you. This is the time set for a pretrial in the matter. Miss Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that the dogs are up to date on their vaccinations and Mr. Williams just needs to go and get a license. So I believe this is going to be a request for another pretrial.
Best or pretrial, just for verification, right? And verification, is that a fair statement, Miss Wicks?
It is.
And what time frame are we thinking?
I will defer.
I know this would be the second adjournment. It's my understanding that it was not conveyed that a full license was needed, so he was unaware. He went and got the vaccinations.
2 to 3 weeks.
That would be preferable. Thank you.
All right, so we'll reset for 2 to 3 weeks for compliance. Wendy's just guessing right now.
Yeah,
You know that,
I'm
right?
not gonna lie.
She's really, she
I
can't
totally
see
am.
anything. She's
She's
just
dark.
guessing,
Yeah.
yeah.
How about the 24th at 9:30?
Sure, June 24th at 9 a.m. So, Mr. Williams, we've reset this for June 24th at 9 a.m. And by that time, you could provide notice, or you could provide whatever documentation to Ms. Wicks, who can provide it to Ms. Wilson. All right, sir?
All right.
All right. So we've set that for June 24th at 9 o'clock. Anything else for the record in 24-00548, Ms. Wilson?
Not for the people.
Ms. Wicks?
No, thank you.
All right, you're all set, Mr. Williams. Thank you for your appearance today.
Okay, we got something from MSU, I think. What's your attorney's name? Taylor Wicks. ICKS? Yeah.
All right, and sir, you are Tom Sinave, is that correct?
Genevieve. That's right, Tom Sinavy.
Tom Sinave, all right, and you're here for your 9:30 case. I just want to warn you, we can hear in the courtroom everything you're saying, so you may want to watch that.
I understand.
All right, thank you. So let's call Mr. Cole's case. All right. All right, so we're on the record in docket 24-01203. That is People of the State of Michigan versus Michael Cole. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender on behalf of Mr. Cole, who is present via the Zoom.
And sir, you are Michael Cole, is that correct?
Yes, Your Honor.
And you can hear me all right, Mr. Cole?
Yes, sir.
All right, thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
I would defer.
Ms. Wicks.
Thank you, Your Honor. At this time, I would be asking for a 2-week adjournment for some investigatory matters to be done.
We'll adjourn for investigatory purpose for 2 weeks out or thereabouts. And we'll reset this pretrial for
June 24th at 9:30.
June 24th at 9:30. So, Mr. Cole, you'll get a notification sent to you at the Mason address. Are you still at that Karam Circle Mason address?
Yes, sir, I am.
All right. You'll get notification sent to you for June 24th at 9:30. All right, sir?
Yes, sir. Thank you for your time.
Anything else for the record in 24-01203, Ms. Wilson?
Not for the people.
Ms. Wicks?
Not for defense, thank you.
All right, Mr. Cole, you're all set. Thank you for your appearance today.
Thank you, sir. Have a good day.
You too.
If we could send Mr. Sinavie into my breakout room, we
All
would
right.
like phone tag for Dick.
Mr. Senevieve, I'm gonna send you you should get a prompt to go to room 1. Meet with your public defender, all right, sir?
I understand. Just Well, we got a clean favor here. Oh, yeah, I thought. Good point. You have to click that. Do you? Let's just wait and see. Good. That's why this is courtroom 4. Excuse me, I'm sorry. I burped. I want to hear. This is me calling. Look right here. Public defender. You have.
All right, Mr. Sinave, we're ready to call your case.
This is Tom.
All right. So we're on the record in docket 23-00281. That is people of the state of Michigan versus Thomas Sinay. Will the parties please, or Sinavy, will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender, on behalf of Mr. Genevieve, who is present over the Zoom application.
And sir, you are Tom Sinavive, is that correct?
That's right.
All right, thank you. And you can hear me all right, Mr. Sinavive?
Yes, I can.
All right. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
I would defer.
Ms. Wicks.
Thank you, Your Honor. At this time, defense would be requesting a final pretrial.
So we'll set it for final pretrial on
June 24th at 8:30.
June 24th at 8:30. We'll set it for corresponding jury trial with on the same because I know we have a July jury trial date, don't we?
Yes, sir. July 8th at 8 a.m.
At AM. May or may not need that depending on the final pretrial. But so Mr. Cine, we've set this for June 24th for final pretrial at 8:30 and jury trial on July 8th at 8:15. And you should get notification sent to your Barnes Road address. Is that still a good address for you, sir?
That is, yes.
All right.
I know what date that was.
Anything else for the record in docket 23-00281, Ms. Wilson?
Not for the people.
Ms. Wicks?
No, thank you.
All right, Mr. Sineve, we'll see you at the final pretrial on June 24th at 8:30.
I understand.
Did you want that by Zoom or?
Please, given
Yeah.
Mr. Genevieve has some medical issues.
Yeah, so via Zoom would be appropriate for that final pretrial. All right, sir?
The jury trials in person.
Yes.
All right, the jury trial will be in person. If we go to July 8th, that'll be in person, but the June 24th final pretrial can be attended by Zoom. Okay, sir?
I understand.
All right. That's all for the record, 23-00281. You're all set, Mr. Sinavie.
Thank you.
Stand.
That is people of the state of Michigan versus Joseph Johnson. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender, on behalf of Mr. Johnson, who is present, standing to my right.
And sir, you are Joseph Johnson, is that correct?
Yes, sir.
All right, thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding, or would you like to do?
I would defer.
Ms. Wicks.
Thank you, Your Honor. If you could swear Mr. Johnson in, I believe after a short factual basis, this could be dismissed.
All right, so I'm going to, Mr. Johnson, I'm gonna have you raise your right hand. Do you solemnly swear or affirm that the that the testimony you're about to give is true to the best of your information, you believe?
Yes, sir.
I just swore him in as if he was doing a search warrant. Raise your right hand. Do you solemnly swear or affirm that the following testimony is true? I know. What am I saying here?
Under the penalty of perjury.
Under the
that's good
penalty.
enough.
Do you swear or affirm that the testimony is true to the best of under the penalty of perjury, sir?
Yes, sir.
All right, thank you. I gotta fix that. Because Thursday, Friday, that's all I did, and now it's completely left my head. Ms. Wicks, would you like to ask some questions of Mr. Johnson?
I would, thank you. Mr. Johnson, is there a time and point that you owned a dog here in the city of Lansing?
Yes.
And did you receive a ticket for that dog not being licensed?
Yes.
Did you then give the dog to a neighbor?
Not farther than the neighbor.
Well, then the neighbor may have given them to, given him to someone else.
Yes.
Okay, but you no longer have care, custody, or control of Kane.
Not at all.
Okay,
No, she got the name wrong. Her name is wrong. That's not the
Do you have care and custody of any dog right now?
Yeah, I do have custody of Kane,
All right, you have custody of Kane.
but that's not.
Is Kane licensed?
Yeah, Kane's licensed.
All right,
He has his tags and everything. She came there for Diamond.
Diamond. And Diamond is the dog you don't.
Having,
All right, how about X? Who's
I don't know what that is.
all right,
yeah, I'm not seeing, even in the report, there is a,
X.
She probably could have been one.
All right. So your indication is you have one dog and that dog is licensed.
Yes.
All right. Miss Wilson.
I have a moment, Your Honor.
All right.
So I guess my concern here is Kane is the dog that's currently in the defendant's possession.
Correct. And
No.
there's an indication that that dog's licensed.
Okay, so there's two dogs on the ticket, so whichever dog is still in custody, I need a license for.
Okay. What
Correct. So, well, I'm not sure which dog they wrote because they didn't indicate who they wrote the ticket for.
she wrote it
They
for-
put no current rabies or license for Diamond, for Kane, or for Pitbull X.
Oh, Pitbull X is the breed, I'm assuming. So it is just the one dog
It
on
gotta
the
be done.
ticket. Okay, I see.
All right.
It has to be done. She definitely didn't ask me. She just asked Kane's
So
name.
is there a license for Diamond?
I
Kane
have
is
no
the
idea.
dog that Mr. Johnson no longer has care, custody. As Kane, but he has made indications that Kane is currently licensed.
All right.
So Kane is the dog that he still has.
Yes,
Okay, so then I need a license for Kane, because
Okay.
Kane
So
is the
then-
dog on the ticket.
Right.
then I would need approximately a 2-week adjournment to give Mr.
So,
Johnson
so
time
what we're doing is we're adjourning for compliance. So if you get Miss Wicks indication that Kane is licensed, the case will be dismissed.
Okay.
Right. So let's set it for final pretrial
if you.
without jury trial.
August,
Or
If you.
Yeah.
That's fine.
June 24th at 8:30.
that should work.
He'll get notice to me that if you just hand it to him, it's for him, he'll get notice to me. He's got it. So,
So we'll set it out for June 24th at 8:30. You should receive notice from the court officer for that date. If you provide any time before that, provide that the dog is licensed to Miss Wicks. She'll make sure that Miss Wilson gets that. And then we may not need that date. They might be dismissed prior to that, okay?
Perfect.
All right. Anything else for the record? And I'll put for compliance on this, just a note for myself. Anything else for the record in 24-00280, Miss Wilson?
Not for the people.
Miss Wicks?
no, thank you.
All right, you should be all set. You'll get notice from my court officer. Thank you for your appearance, Mr. That's it.
See you. Okay, yeah, I had seen the, but yeah, if you give him a call. Even later. Email, if you can.
Just for the next one.
The notice would be for the next date here.
And don't forget your court date in front of Judge Simmons this Thursday,
Okay.
Friday,
The 13th.
the
Yeah, I got it.
13th.
Yeah, I got it posted.
So yeah, this Thursday, it'll be either on Zoom or just right across.
You might wanna check with that, Judge Simmons is out.
That's right, so I'm assuming Judge
So
Ward is
whoever's
probably
covering
handling.
Judge
Sure, Judge Ward's doing the PCCs.
I'm assuming, because normally they tend to be on the same schedule and it's a. And I'm sure Luke's had good contact.
Okay,
I'm
she
sure
did
they're-
say she might come in and do her morning docket. She was supposed to be off, but
Okay,
somehow she ended up.
yeah, I will, Luke can handle the finer. Detail.
And docket 24-01-119, that is people of the state of Michigan versus Prophet Charles. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender, on behalf of Mr. Charles, who is not present, but if I could be heard on why.
Sure, you may proceed.
Mr. Charles, it is my information and understanding, is down in LPD lockup at this point.
So was he,
So if I might chime in, when I was looking Mr. Charles up in our system and I did see there was a case in review that another APA was currently working on. So I'm guessing he was picked up on another charge and it's currently waiting that.
let's adjourn.
Yep.
No, let's adjourn.
Sounds great.
Until he works all that stuff out, I think we can adjourn.
Sounds great.
Yeah, so let's adjourn and reset
Even a week should be
this
plenty,
pretrial.
as the court schedule allows, of course.
I think it picked up on you, it's just a rain.
It was a
Wendy, I didn't ask questions I didn't want to know the answer to.
Couple weeks, yeah.
Yeah, a week to,
Yeah.
whatever.
Figure he's got other things going on and then we'll figure out this driving while license suspended case.
9:30 on 6/24.
Okay.
24 at 9:30 for the second pretrial. There'll be lots of variables to work with on that. All right, we've reset this for June 24th at 9:30 because we learned that Mr. Prophet may be being arraigned on other charges or something along those lines. And so we'll set it for June 24th at 9:30 and he'll receive notice at his last known address with the court.
Okay.
Anything else for the record in docket 24-01-1119, Ms. Wilson?
not for the people.
Ms. Wicks,
Not for defense, thank you.
did you want to go ahead and call Hall?
Yeah.
All right, so we're on the record in docket 15-01425. That is people of the state of Michigan versus Alexander Hall. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Alexander Hall.
All right, this is the time set for a free trial in the matter. I think we all remember this case because it's an older case. And it was adjourned a couple times. It was adjourned at least a couple times for protective services discovery request, but that's from 10 years ago, I would assume. And then we reset it for pretrial on today's date. Ms. Wilson, how we proceed?
Thank you, Your Honor. I believe the discovery issues have been resolved. At this point, at the last date, Mr. Hall also did not appear, so I'd be requesting a bench warrant.
All right, Mr. Lee.
Your Honor, I have reached out to Mr. Hall and attempted to contact him via phone. My latest attempt, the number was disconnected. So I have emailed him as that is the only source of contact I have with him at this point. And the only alternative would be to waive his appearance and set up for a final pretrial that hopes that we can contact him. So I leave it to the court's discretion.
All right, thank you, Mr. Lee. I'm going to go ahead and indicate, because he missed last time. The previous time he was here, and I remember the case. So he knows he should be here, at least keep in contact with everybody, keep in contact with his attorney. I'm going to issue a bench warrant with the 48-hour hold. So he's got 48 hour. This is an assault of a pattern. So we'll issue a bench warrant with a 48-hour hold, and then Mr. Lee, just contact us if you end up getting any contact from him.
I absolutely will. Thank you, Your Honor.
Anything else for the record in 1501425, Ms. Wilson?
Not for the people.
Mr. Lee.
Nothing further, Your
All
Honor.
right. Thank you for your appearance today. All right, Mr. Carter, you're the last case of the day.
Okay. I'm gonna just check.
You want to check the hall and. It's conflict counsel on that, isn't it?
I think so, maybe.
It's a DV, but I think
Yeah.
he's conflict counsel. I don't know if he's ever, has he gotten any?
He spoke to him last time when he showed up late.
Oh, don't.
No.
No luck,
I just
Mr.
wanted-
Carter?
hold it before you-
No luck.
before we need to throw it. I'll do it. You're fine.
All right, so we're on the record in docket 24-01404. That is people of the state of Michigan versus Darren Cottenham. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Carter.
May it please the court, David B. Carter Jr. on behalf of Mr. Cottenham, who is not present.
This was scheduled for 9 o'clock. It is now 10:07. And it would appear that Mr. Cottenham has failed to appear. Mr. Carter, you are conflict counsel in this case, is that correct?
I am, and the information that was forwarded to my office was, he had no phone number, so I cannot call him.
All right.
I've tried to email him to have him call me. I believe the address on the information is the address in which he cannot have contact at, so I can't even reach him by that way either.
Yeah, I think, let me see, he didn't give an address at the arraignment.
Right.
Yeah.
If I may, the last time we were here, Mr. Cottenham zoomed in rather late, just as I was leaving the court, your courtroom. We noticed he was on the screen, and I believe we indicated that to him that this was going to get reset and to him to contact me, and I
Right.
haven't heard.
So Ms. Wilson, how would you like to proceed?
Thank you, Your Honor. This is two assaultive offenses. As Mr. Carter stated, Mr. Cottenham showed up rather late last time. I'm concerned about the failure to appear here today and the lack of contact he's had with his attorney. I'd be requesting a bench warrant.
All right.
And obviously, I can appreciate that position, but with some sympathy that the individual is homeless, I'd ask the court to hold it for 48 hours. I will do my best to let the court know if I get any contact with him.
We've had pseudo contact with Mr. Cottenham. This is a conflict counsel case. I will hold it for 48 hours. So bench warrant and bond forfeiture with a 48-hour hold, which is within the court's discretion. And then we'll go from there. We've had some contact with him. It is a little, it's a little, this was arraigned, and I don't think the address was indicated arraignment. And as I look at it, he can't go back to that address where he's getting notice. And then, but he's also not keeping contact with his attorney, who he knows he's got one now because he showed up last time, but we told him he had one. So I feel good with the bench warrant bond forfeiture, but I'll hold it and wait to hear from Mr. Carter.
Thank you, Your Honor.
Anything?
I will tickle it by Wednesday. I
All
will
right.
Let you know.
That sounds good. Anything else for the record in 24-01404? Ms. Wilson,
Not for the people.
Mr. Carter.
Not to the defense.
All
Thank
right,
you.
you're all set. Do you have some stuff this afternoon?
Yeah, we've got some sentence things.
Oh, Your Honor, if you do, I don't know
Oh,
if you
yeah.
have the file, Mr. Bim's motion.
The dog motion?
No.
No,
Well, I mean, if
that's-
you'd like to rule on that, that is fine.
Yeah,
I think
I-
I think we are ruling on that.
The Chapman one,
Which,
Chapman's the dog, Mims is the discovery.
okay, Mims is a discovery.
No,
Yeah, and I think that one's been resolved.
Yes,
No.
Oh, so Mims, so the discovery's been resolved.
yes.
All right. All right. And I've already ruled on the Chapman. They told you that.
No,
Well, you've ruled on,
similar cases,
Similar.
not actually
Yeah.
ruled on.
You know, we're
we know
running through the
what
whole
we're
thing
doing,
again. Yeah.
yes.
Yeah.
I mean, if you want to rule on it now and
Yeah,
save us
no,
all time this
no,
afternoon.
No, we're gonna have students watching you, so
Oh,
I'm giving you
okay.
a warning that we're running through the whole
The whole shebang.
rigmarole. Exactly.
Okay,
We have. So those are the two it's set for 2:30. And then the 131s are Herrera,
Mhm.
yes.
non-public. Porter Miller is an arraignment, and then two sentences.
Mhm.
Travis and Wilson.
I think Travis will, nope, Travis is not public, never mind.
It's,
Um,
it's too many cases.
It's a lot.
That's the first indication that you have too many cases. And then Ms. Wicks, you're covering those?
Mr. Lee has some of them, I have.
All right. 23033740. That is People of the State of Michigan versus Corey Wilson. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Zaney.
Good afternoon, Edward Zane, on behalf of Mr. Wilson, Corey Wilson is present to my right, Your Honor.
And sir, you are Corey Wilson, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for sentencing today. Before I'll give the prosecution a chance to give comment, but there is restitution in the matter, is that correct?
There is, Your Honor, there is an OWI cost recovery that was previously submitted to the court in the amount of $680.54. It also looks like probation has reached out to the other car that was involved in this, and she's requesting restitution for towing fees. I have provided her with Mr. Wilson's insurance information that was not previously known at the time of this incident. I don't know whether insurance covers that, so I would leave it to the discretion of the court.
Okay, that's the $430 restitution.
Correct. Yep.
All right, those are the two matters that are so yeah, those are the two I have the LPD recovery and then the restitution to a Miss Troyer. All right. Mr. Zaney, have you had the opportunity to go over the pre-sentence report with your client?
We have, Your Honor.
Any additions, deletions, or corrections?
Yes, the first page of the report indicating he had 1 day jail credit. I understand in my discussions with Mr. Wilson, it should be 3 days jail credit. Then no other additions, corrections, or deletions to the report that I see. As far as the restitution matter, I did provide the insurance claim information to Madam Prosecutor. I think the onus was on that person to report it to get their reimbursement. So I'm not sure if it's appropriate. We just reserve restitution so long as I can investigate and ascertain whether or not insurance actually paid this out.
Your Honor, if I could interject.
You may.
This is partially on me. It got stuck at the bottom of a pile and I didn't relate to her until earlier today when I was looking at the report. So that's on me that she hasn't been able to reach out to the insurance yet. Whether or not insurance will eventually pay for it, I don't know.
Should we just set it for restitution hearing then?
The court knows my feelings
The
about
restitution
those
hearing.
right now.
Well, I mean, because I guess I don't know what the restitution hearing, what restitution is, if insurance is paying out of pocket,
Right.
paying.
This was a parked vehicle, Your Honor. They have a mandate to pay that obligation.
Yeah, but I mean, they do, but I mean,
I guess, Your
this
Honor.
was a parked vehicle and it was hit by your client. It's a problem.
Oh, I'm sure it qualifies under restitution,
Right.
sure. We don't dispute the bill. I think the reality is if it's paid by insurance, he gets credit for it.
Correct.
Right.
That's.
I think the appropriate way to go about it is to not order it at this time. He's on probation. There's a court rule that allows me to file a motion while he's on probation to reevaluate restitution if we have more information. If that's what happens
'Cause you-
later, that's what we'll do.
Right, because you don't know.
'Cause I don't
what-
know,
You
right.
don't know. is the
Yes, and
problem.
again, that's on me.
All right. Yeah, so I mean, and it's, I don't want him to pay more than he has to, and if insurance is taking care of it, then, so I guess, both counsel, we're all three on the same page. I guess I'm reluctant not to order restitution. I mean, just because I don't know, what I'd like to do is set it for restitution hearing, because I know it's your favorite.
It's my favorite. It's also though a question, and the court knows I've done a very deep dive into the
Right,
restitution
right.
statutes for other reasons. My understanding of the proper order of things is at sentencing, if restitution is unknown, it's set at sentencing, and if the people or the defense later find information that modifies that, we file a motion, and then it gets set for a separate
Set
hearing.
And my understanding of restitution is I have to reserve the issue of restitution at the time of to reserve the right to the restitution hearing.
Right.
And I think that's what we're doing.
Yeah.
If Your Honor, we do know the number, we just don't know who's gonna pay
We
it.
just don't know who's
So,
gonna pay. it.
All we would say is order the restitution as you see fit with the understanding and the expectation that if insurance pays it, he's credited for it.
Fair enough.
That's fair. Yeah.
That's, yeah, all
We're
right.
not wasting resources for running
Yeah.
any kind of value. We don't.
Because that way it's reduced, any amount is reduced. And then it won't be more than a request, but it could be much less than the request depending on the
It could.
on the insurance. Okay. Yeah, I think we're getting the same place, whether
Yes.
in the same, just in different ways. All right. So let's do that. Anything on allocution, Mr. Zaney, and then I'll hear from Mr. Wilson, and then I'll hear from Ms. Wilson if she has anything else to say. Mr. Zaney, allocution.
Yes, you're upfront. I recognize the hardships of this case. I recognize the BAC. I recognize there's an accident with the parked vehicle. But I think what we did here is present the court with sufficient information to kind of understand how we got here and talk about what he's done since. And I think that's a pretty strong indicator of how things are going to go for him in the future. Mr. Wilson, as the court knows, was a .272 with an accident. We recognize that, accept it. Leading up to this, Mr. Wilson, as indicated in the reports on the PSI, he has a TBI from his service in the military. He has a 2005 conviction at the time in which he was serving. You know, it's almost 20 years now when you think about it. He's 70% disabled through the VA. He has gone and, you know, I would say paid the second ultimate price, right, in service of our country. So this occurred in August of last year. Let's talk about since then what's happened. He's been enrolled in the VA program for 3 months. He's extremely close to finishing that VA program as directed to him by Dr. Deb Smith. Dr. Smith also noted these circumstances that I discussed. He's completed the highway safety and the MAD impact panel. So I think he gets both the social and scientific consequences or understanding the educational aspects of this type of behavior. So the question is, and I have, is does he need the 10 months probation? I don't think so. I would ask the court to consider a shorter term where allow him discharge early on, or in the alternative, upon his successful completion of the VA program, having allowed to be eligible for dismissal from probation. We are achieving the rehabilitative goals in utilizing all the tools that he's done proactively, as his case, you know, has been pending for quite some time.
Thank you. The VA program, is that both mental health counseling and the outpatient that he's in?
Correct. It's a substance abuse counseling program, but he does meet with a counselor one time a week. Is it monthly? Monthly, monthly to address some of those issues. And as the court knows, with the VA, they have regular checkups and things to make sure that his programming and his services are covered. And
so that is part of the veterans, because here that Ms. Smith indicated alcohol testing per court protocol, and then she indicates outpatient treatment through the Veterans Administrative Counseling. And then here on the judgment of sentence, it says continue with mental health counseling and sign a release. So is it a twofer or how does that work?
It's my understanding it's the same program by virtue of also dealing with some of the mental health issues and aspects of substance abuse related addictions.
And Mr. Wilson has completed at least one online victim impact panel. And then I've also have the certification of completion for the highway safety seminar. Those were both done. One was done in March of 24 and one was done in February 24. So, I mean, the strides have already been made concerning that treatment. When's his out date for the if he has one, for the Veterans Administration?
We don't have a specific date. My understanding is approximately a month left in that program. So he's near completion.
Near completion. All right. Mr. Wilson, is there anything you'd like to say to the court before the court passes sentence?
Leave it to the court's discretion.
All right. Mr. Wilson, is there anything you'd like to say to the court?
Not at this time, Your Honor.
All right, thank you. Well, you pose quite a problem, Mr. Wilson, not a problem, but an issue here. One of the issues there is that you've been able to recover and you've done everything we requested, okay? And you've done it through the VA, which for me is a big deal, okay? So in that regard, I think that's been helpful. That's been helpful. And then you were sober, or you don't have anything on your record since 2005. Okay, that was the impaired out of 76 district court. So, and then you had some of the traumatic brain injury from the VA, and that was diagnosed along with this. But then you were stopped on this date, and that's about as high as you can get without causing yourself some real damage. Okay, you understand that. So those are my concerns. Those are the nature of my concerns. Just I'm sharing you the nature of my concerns is, I mean, you're way up there. You know, I've been involved in criminal law in 30 years. That's maybe the top 5, maybe the top 6. That's some experience there. All right. Or lack of experience, or, they both can get you way up there. Having some experience, so you get a high tolerance, or you have none. So that's my concern. But I do agree with your counsel that you've done a lot so I'm gonna reduce your probation. Okay. I'm not gonna reduce it down to because you're done in a month, but I'd like the court to keep some supervision over you to make sure that this isn't a problem. Go ahead, sir.
Well, I mean, if the court will allow me, I would extend the I actually kind of enjoy the VA sessions that I do. If I can extend them.
You can. I mean, I'm gonna drop you down from the 10 months to probation. But I mean, it seems to be working for you. And the whole point here is to whatever works, right? It's not a one size fits all, it's whatever works. And everybody comes to it from a different place. And I think that's the key. I think we have a tendency to try to make one size fit all, and that's not realistic. I mean, it's not realistic to me. It's not realistic to anybody who's seen or been through the process. It just doesn't work that way. So what I'm going to do is I'm going to reduce your probation, but I want you, but you understand the problem here. Okay? The problem. I mean, I'm not. I mean, you're not a kid, and I'm not going to treat you like a kid. Okay. So the operating, there's 3 days credit. So I'm gonna sentence you to 60 days in jail beginning June 10th, 2024. Credit is given for 3 days credit. And then I'm gonna suspend the 57 days upon successful completion of probation. Okay. And then I'm gonna reduce your probation because I think, and you've got other stuff going on because you got some restitution. There's insurance that's going to be looked at into. I'm going to hit you with some fines and costs. All right. So I want you to walk away knowing everything that's coming at you, so you're prepared. All right. The fines and costs for this, I'm going to set fines and costs at $250 fine, $250 cost. That's $500. Crime victims' rights fee of $75. State minimum court cost fee of $50. I'll order the restitution at $430 to Miss Troyer. $300. That's going to change because I'm going to limit that at 30. That's $30 a month, and I'm only going to put you on probation for 6 months. Okay, that's down from the 10 to the 6. So that'll be $30 a month. It'll be $180 in all for probation costs. And then you've got your LPD coverage, which is $680. So I'm going to give you a grand total of that. And that's probably what's coming out of here is it's somewhat expensive, but you're doing everything you're supposed to do. You know that. So the grand total I have is $1,915.54. The restitution is made to Esther Troyer if it's not been made already. Probation is for 6 months via Zoom. I'm going to have no contact with the victim in this case, and we'll make Esther Troyer, and that hasn't been an issue, but I'll just put on here. That's to be within 2,000 feet of her victim life, which I don't know, you've had any contact with her off. I don't even know if you know what she looks like, okay? So I mean, but if I put it on here, at least we treat her as someone that, you know, that, yeah, you certainly made a difference in there in that day, right? So no assault or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription, submit to random PBTs over the course of 6 months, your analysis. And as you know, that's just a part of making sure that, you know, we're doing what we're supposed to do. No bars or nightclubs. I'm going to go with the continue with mental health counseling. That seems to work, and whatever outpatient treatment they have. All right. And you seem to be benefiting from that. So, and it's whatever outpatient treatment comes out of that counseling. Do not purchase or possess firearms, ammunition, or weapons of any kinds. We'll add that. Conviction of report to Secretary of State. Do you have any questions of me? You understand what I've tried to do here.
Yes,
We've
sir.
extended it. We're doing what works with you, which seems to be work. The restitution is really the restitution in regards to Ms. Troyer is really just to set it and then to see what insurance pays for. The LPD cost of recovery speak for itself. All right. And then we're going to go to 6 months. Even after that, even after all probation's done, if it's working for you, why not? Right. You know, Ms. Wilson's probably heard me say this more than I'm not concerned about Corey Wilson today, because if you violate probation, you start taking away things from me and you end up in jail. And I just don't see the world. I don't think that's helpful. You know, I want to be helpful in district court. But if I start losing stuff, then you got to go to jail, because I worry about the Esther Troyers of the world, right? However, I'm worried about Corey Wilson 5 years from today, when you got to make good decisions. You're out on your own. You don't have the jurisdiction of the court. And if the VA is helping, then rush to it and do everything you can, because that's what I worry about. I worry about Corey Wilson 5 years from now, not right now. Right now, we got a lot of sticks, right? You know, we got a lot of ways to say do what we say. 5 years from now, there's nothing out there. So you got to put the parameters on. You know that, right? All right. Anything else for the record in 2303-740, Ms. Wilson?
Not for the people, no.
Mr. Zane.
None from defense. Your Honor.
All right, I'm going to sign this. We'll be all set. You might want to check down to see your probation agent is in the 5th floor, and we'll go from there. All right, Mr. Wilson?
Yes,
You're all
sir.
set.
Thank you, Your Honor.
That the pretty one?
That's the pretty one.
Yeah.
On the way in the hallway or in the court.
It's your choice.
I'll have them here for me.
Are they right here?
It should say CJ. All right, Ms. Wilson, where do you want to go?
I believe we're ready on Travis.
All right. Ms. Clifford Travis?
Yes.
On the record in docket 24-00546. That is people of the state of Michigan versus Clifford Travis Jr. Would the parties please indicate their presence for the record, Ms. Wilson?
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Clifford Travis Jr.
All right, and sir, you are Clifford Travis Jr., is that correct?
Yes, sir.
All right, thank you. This is the time set for a sentencing in the matter. Ms. Wilson, is there any restitution on this file?
There is not, Your Honor. And I did have one thing to bring to the court's attention before we resume. There was a P 53 violation that was at sentencing or at plea that we were holding in abeyance until sentencing. I see it's not on the docket today. I'm wondering if we're doing anything with that today.
We can, yeah,
Okay.
I've got it right here. I have, it looks like there was an exclusion zone. Something was done on the exclusion zone.
Yeah,
It wasn't set for today, but
there were jail calls previous to the exclusion zone.
all right. And were there additional charges coming out of that, or?
There were not as part of this plea arrangement, but the court was holding it in abeyance until today.
All right, so, so what information do you have? Do you have any information that there's been continued contact?
Not that I've had, no.
All right. So, so do you have any objection to me dismissing the PA 53 in regards, there would be a continued no contact order?
I have no objection to the dismissal of the PA 53. I just wanted to make sure that we got it all done today, so it wasn't hanging out there.
So let's dismiss the PA 53. So, yeah, so we don't reschedule it needlessly. All right, so that was part of the original plea agreement, was a dismissal
Correct.
of the no contact order.
Yep.
All right. Thank you, Ms. Wilson. Mr. Lee, have you had the opportunity to go through the pre-sentence report with your clients?
Yes, I have, Your Honor.
Any additions, deletions, or corrections?
No additions, deletions, or corrections.
All right, allocution.
Thank you, Your Honor. Mr. Travis has cooperated fully in this matter. He takes full responsibility as the pre-sentence investigation report attests to. He was open and honest throughout the interview. He took ownership of the situation and said he regretted what had happened, that it was out of character for him, and that he would commit to any sort of programming and or orders of the court to help him to further better himself in dealing with his anger. We don't, we reiterate the conclusions of the pre-sentence investigation report. We think that a period of probation is appropriate with DV programming and a continuation of the no contact order. Mr. Travis reports that he has no interest and or any thoughts of establishing contact. We do ask that the court would consider the tether. There's been these continuing ongoing sorts of issues with the tether, driving to and from work, violating the exclusion zone, the tether going off when he's been in court and so forth. Other than that, Your Honor, we agree with the recommendations of the pre-sentence investigation report.
All right, thank you. Mr. Travis, is there anything you'd like to say to the court before the court passes sentence?
Yes, sir. I want to start my class. I need to say B right away.
You want to what?
Start my classes.
You want to stop or start?
Start.
Well, I think that's a good, we'll talk about that because I think the classes would be important. I'm trying to figure out your criminal history because you have a limited criminal history, but I do have some items. Were you out of Tennessee or Memphis at one point in time? Yeah, so you have some extensive criminal history out of Tennessee. Okay, is that a yes, sir?
Yeah.
All right. So this isn't your first go around with the system. You've got and that I'm not gonna pay that much mind here, okay? But you understand that I know that this is a problem, right?
Yeah, see, yeah.
I mean, there's quite a history out of Tennessee.
Yeah, I know what you're saying on that, on the ones you looking at on
Yes.
them. They had it coming to them. I just had, I'm gonna put that out there. I man up instead of, they had they coming to him.
Right.
I ain't gonna deny, I ain't gonna regret it. They deserve that.
Right. And you've got some felonies and you've got some other, but this is, I'm gonna treat this a little differently, all right? Because this, you end up hitting somebody you allegedly care about, right? That's the heart of domestic violence.
Yes.
And so if we can work on that, let's work on that, right? Let's see what we can do.
Yeah, I can work on it.
All right, well, and we're gonna kind of start a little barter system here, okay? Because I know you want the GPS to be reduced, but let's start your classes. Let's get that. And then as you start doing those classes, then that GPS we can put that aside, all right? I think that's fair, okay? And you've been open and honest about everything that's occurred in this event. All right, you really have. You came in, you said, you took responsibility. You said the things that they wanted to hear, but they're a little worried, you know? And after reading the CCH, you can understand that.
Yeah.
You can understand that. Regardless, you can understand. So, so I'm going to indicate for the guilty plea on April 12, 2024. Those are no contest pleas as to domestic violence. That you spend 93 days in jail, credits given for 21 days. Suspend the sentence upon probation, so no upfront jail, which is 72 days upon successful completion of probation. I'm gonna hit you with $250 fines and $250 costs. Crime victims' rights fee of $75, state minimum court cost fee of $50, probation of $270, and that'll be 9 months. Okay, 9 months probation. So I'm going to give you a grand total of all that. So that's $895 can be paid over the course of your probation. You should have no contact with the victim, in this case, Latricia Travis. That's 2,000 feet of where she works, goes to school, but without the consent of this court. So even if Ms. Travis says to you, like, you can come forward, you can come to me, it's an order of this court which allows that. Okay, that's the key, because we get in trouble there when you're saying I wasn't breaking the order because she said I could come or he said I could come, and the fact is only the judge can tell you that, right? Only the judge can only I'm the only one who can dismiss my order. Okay.
Yeah, I ain't trying to go nowhere every day. I ain't trying to come back.
All right. No assaultive or threatening behavior, no use of possession, alcohol, marijuana, or controlled substance as part of your probation. Submit to random PBTs or urinalysis as directed by your probation officer. No bars or nightclubs is probably a good idea. And then you're going to start the batters intervention program. All right. You start that. And then when I get an indication that you've started the batters intervention statement intake, and you've done one session of that, the probation is going to come to me, and they're going to start saying, all right, Mr. Travis is doing what he needs to do. So let's talk about the GPS. Because if you get enrolled and then you get one session under your belt, I'm not going to worry too much about the GPS. Okay, that GPS will be that's going to come to me, and I'm going to say, all right, he's doing what he's supposed to do. Let's take it off. All right. If you don't do what you're supposed to do, then I'm going to wonder, all right, do we need to get Mr. Travis in here and talk to him about, what he's going to do here? So I'm going to have you do the batters intervention and it's going to be at the request of probation. If you do the batters intervention and go to one class, then we'll start taking a look at removing the GPS. All right. Obtain and maintain employment as indicated. Not purchase or possess firearms, ammunition, or weapons of any kind. Do you have any questions of me concerning the judgment of sentence, Mr. Travis?
No, sir.
All right. Go down to the 5th floor, find out who your probation agent is. Talk to them for a while. Make sure you know who it is and who you're supposed to talk to. I'm going to wait. In about a month, I'm going to contact them. I'm going to say, all right, how's Mr. Travis doing? Like, is he involved in the domestic batters program? Does he have anything under his belt? And if it looks good, I don't see a reason why we need to keep that GPS on. Okay.
Yes, sir.
I really don't. All right. anything else for the record in docket 24000546, Ms. Wilson?
Half of the people.
Mr. Lee?
Nothing further, Your Honor.
All right, Mr. Travis, good luck to you. Hopefully, we don't see a lot of each other, right?
I'm not.
All right.
I want to ask one question. What
Okay.
you looking at, and nobody's gonna see it. What you
But-
look at?
Your Tennessee history?
Yeah.
It's on your abstract. So what they do is they run your social security number, and that's how they get the extra abstract. So it's on there. I don't know if an employer is going to do that, but there's a history there. Okay.
Yeah.
All right.
Okay.
You want Yolanda to drop us out today, she can bring up the non-public case so that we can let the students in because we got.
Yeah, let's do the non-public.
Information.
Can I see the CCH? Because I don't have an out of state online, and now
Are you sure you want to?
I do, yeah.
I'm curious.
I don't know if you really want to,
I would
Abigail,
like
'cause
to.
you're gonna start questioning my sentence, but
No,
There-
I think it was probably right, but he said some stuff there that.
Yeah, no,
now
I'm with
like-
Abby. That's
Yeah.
why I'm behind Abby now. So I'm like, no, I'm also, but
We'll have
no,
to
not
do
gonna lie,
that.
they deserve that one. And I'm like,
I mean, it's nothing that it's not violent in any way.
Okay.
Except he did some time for a CSC.
okay,
No.
deserve.
He must have been talking about
I don't want
something else.
I'm hopeful.
I can't imagine somebody saying they just.
No, I think those are,
Okay,
he,
thank you, Yolanda.
he's got a lot of.
I figured you knew all that, but you know.
That's just the first page.
I left everybody on purpose for the civil matters.
All right.
Just so we can get our
Oh,
docket.
Mr. Loss free to trope.
Yeah, we're just gonna leave everybody there for a few minutes unless you want them in.
Probably, yeah.
I think it was the forgeries that he was talking about. I didn't put it in any.
Yeah.
Professor Scott, how are you?
I am fine, Your Honor. We are about to head out. We understand you got a non-public hearing, so we'll come back. Well, we won't come back, but you got the students excited about coming back.
All right. All right. So are you with the students today or?
I am coming in with the students.
All right.
We came in, this is a former student that's a law enforcement officer down in Detroit.
How are you? Good to
But we
meet you.
have, I just stopped by to do that and I was gonna take a peek, but I didn't know you have another case in between, so I'll do it next time.
Yeah, we've got one that we got empty the courtroom in because it's non-reporting.
Okay.
But then after that, it's free reign.
Wildly different than
All
what I
right.
have.
All
Thank
right.
you, Your Honor.
Take care.
Thank you, Judge.
Are you sure that,
I'm good, yeah.
are you sure
I
you wanted to
dropped
see that?
something. No, I'm good. I was just curious because I have just an in-state.
Yeah, he's got plenty.
Wow, yeah, that's a lot.
Well, I mean, he knows what he's supposed to do. And
The
so,
magic of lean.
Yep.
yeah, and it's also that social security number is,
Yep.
it can be telling.
You know, it's out of state by name and I said if you get it.
Yeah, but here's this was my problem. You can have identical names,
Yeah.
but you can't have you're not supposed to have identical social security
Correct.
numbers.
And
Oh.
even technically, you could have identical fingerprints.
Yes.
Yes,
Yeah.
my twins do.
Yep.
But that, if you went to the trouble of social security number, it's.
Yep.
All right, that's Mr. Travis.
Is Herrera today?
The people who are on Zoom are civil matters, so I believe the PVA,
Aaron Hickory.
I don't believe
Yeah.
is here.
Yeah.
And I don't believe Ms. Herrera is here either.
That's
Unless
kind of
she's in the
surprising.
hallway.
Yeah, no, that's what I was gonna go check one more time, but she wasn't.
Alright.
I've already made a round of the floor twice, but. Gonna go do one more.
Oh, that Miss Herrera is the one that's,
She's got an impaired.
I kind of find that surprising.
So,
I know,
So
she's-
did I,
yeah,
based on
she's
Ms.
come to
Schroeder's
everything.
notes.
Yeah,
She was pregnant.
Oh, that realistically could be,
I
is,
can't remember how far along she was, but
I did note in Erin's notes that she did say.
And then the non-public is Miss Henrietta,
yes.
and that was,
And I think Mr. Lee needed to talk to her.
Yes. I do
Yeah.
need to speak.
yeah, let's bring her up and you,
Yolanda was gonna grab her in around.
Yes.
all right. Is Porter Miller here?
I do not believe so.
Yeah, no, there has been nobody in the
All right.
hallway.
And the waiting room, I'm only showing civil matters.
Should I take care of that civil matter? I think I should. We got some time,
Probably oh,
or else, because I want Mr. Lee to be able to talk to his client.
At least according to our notes, she was 6 months pregnant in March.
that'll do it.
Yeah.
With
Yeah.
twins.
Oh, jeez.
So-
Yeah.
I'm just kind of surprised because she's
She's attended
Yeah, she
everything,
has.
so
Yes.
my guess is that has something to do with.
Yeah, and I'm guessing that's why I haven't received a call back. Is
Yep.
if, you know, she was in labor or
Yep.
about to be, or,
Yep,
you know,
just done.
yeah, you know, picking up your cell phone for your attorney isn't probably at the, or returning voicemails at that point. I
I
get
think she's
it.
doing priorities there.
Yeah, you know,
I
it's
would
not
be.
very often I say rank things over court,
Yeah.
but, you know, giving birth might be one of them.
Henrietta husband is
You're welcome.
that the non-public?
Yeah. I'm
So-
assuming that's a 7411 one.
Yeah, that's. What do we have her time at? Could you look?
162.
I can't find her. Talking about, with the time that she got 173-day balance from Judge Alderson, and with the accrued time, I came up with 162.
So Mr. Lee, you can tell her. Because I did a little sheet, Judge Alderson gave her initially. And you may know this, 180 days, 173 suspended. And then we came up that she has 6 more days on that. So she's got 167 left. And then we have a note from her indicating she was in the Sault Ste. Marie jail for about 2 weeks.
Yeah, I can't, I looked.
But we have that note from her, but we can't confirm that. It's March 28th to April 5th of 2019.
Did she just plead to the use of the analog?
She pled guilty to count 1 and 2. Use and analog. So 2 1 years?
Yeah.
Yeah. So she's looking, even if I give her a couple weeks, if the couple weeks in the county for Clare County, she's probably looking at 167 minus 14. She's probably looking at 53, 6, 9, 12, 5 months. She's got 5 months left on her sentence from Judge Alderson. 153 days. What's that?
They're gonna revoke 7411.
Yeah, and everything, all the recommendations are, and you can share this with her if you want, are to revoke, to remand her, revoke, put her in jail. They don't want to work with her. She's been gone since 2019, I think. Did you want to share that with her?
Oh, yeah, I'll definitely be sharing that.
Or did you want to share the pink sheet with her?
Oh, I've got a copy.
Okay, all right, yeah.
When did you see the email from Carter?
I'm working on it.
And
Carter's
her last
scheduling
test was positive for THC, according to them. But, you know, they definitely do not want to work with her.
Now, then, just so that I'm clear, She was completing her probation in Sault Ste. Marie.
She was in custody on something else, and she sent us a letter saying, hey, I'm in the Sioux for the next 2 weeks, and I'd like to get concurrent time. But we didn't know what she was in on there.
Gotcha.
So, and then we completely lost, then we lost track for 220. So, I mean, she's got 5 months left on her sentence. I don't know if I'm gonna give her 5 months, but she's probably looking at some jail time.
Yeah, she's been gone for, I noticed that, how old this kid
Yeah,
was.
it's,
Okay.
she's probably not looking at all 5 months, but it's a possibility for that 152, 153 days. She's probably looking at half of that.
Gotcha. Okay. All right, I will let her know, Your Honor. I'm not anticipating a hearing.
Should we, let me see if I can pull up well, I have the order to sign. It's in my to sign bin. Got lawyers fighting on another case, and that's always entertaining when lawyers are fighting.
Lawyers, who needs them?
Yeah, they're fighting over lawyer stuff.
We never did another civil case, and my feelings would not be hurt.
It's still better. Judge Ward had a civil case made in front of her over a karaoke machine.
Oh my
not
God.
like
And I
rental
mean,
company.
that's the kind of stuff that just makes you crazy. It really does.
Like
And not like a
why?
rental
Why?
company.
Yeah.
All right, Mr. Lee, I'm gonna let you talk to your client for a little bit.
All right.
Okay. That is People of the State of Michigan versus Henrietta Husband. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Henrietta Husband.
And ma'am, you are Henrietta Husband, is that correct?
Yes.
All right, thank you. This is the time set for a probation violation hearing. Ms. Wilson, how are we proceeding
I would
today?
defer.
Mr. Lee.
Your Honor, I have consulted with Ms. Husband, and she is not disputing the allegations and will plead guilty.
All right. And so just so we're on the, this is for allegations from Heather Dahosky is that July 18th? I'm sorry, then it's June 2019.
Yes, that's it.
All right. All right, and Ms. Husband, that's a fair statement. You're going to plead responsible to the allegations that have been made by Heather Dahosky, who is the probation officer who reported the conduct. You understand you have a right to a hearing in this matter?
Yes.
You could have a hearing. Mr. Lee could represent you, cross-examine, contest any charges brought against you for this case. It's my understanding it is your wish today to admit responsibility to the allegations and we go to allocution. Is that correct? All right, I'm gonna have you raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Okay, these are for allegations. These are for allegations, and I just lost the page. These are for allegations made by your probation agent indicating that and she requested the bench warrant for June 21st, 2019, was signed by Judge Alderson on June 21st, 2019. First allegation is that you have not reported to Ms. Dahosky since May 1st of 2019. That was on, she indicated that on June 21st. I understand this is quite some time ago, but is that a true allegation that you failed to report to the probation agent as of May 1st, 2019?
Yes.
And that you failed to make a payment since July 11th, 2018, so you still had a balance of $690. And you failed to do random testing on May 15th, May 24th, May 26th, June 7th, and June 13th of 2018. And then they closed your case due to the absences.
Yes.
All right. I find the probation violation admissions to be knowing, voluntarily, and accurately made. I'm going to indicate, so to admitted to violation, these are not an order of it, they're just numbered as 3, 6, and 11. Anything towards the admission of the violations, Ms. Wilson?
No, Your Honor, thank you.
Anything on allocution of Mr. Lee on the sentencing?
Thank you, Your Honor. We would ask the court to consider that Ms. Husband voluntarily turned herself in. She admits that she essentially absconded from probation, but has been living a fully functional life, working full time. She has become engaged to be married, and most importantly, has not had any more contact with law enforcement and or any new charges. So we would ask the court to consider that in drafting a sentence for Ms. Husband.
Thank you. Ms. Wilson, anything on the court before the court passes sentence on this matter?
I leave it to the court's discretion.
Ms. Husband, is there anything you'd like to say to the court before the court passes sentence pursuant to this matter?
No, thank you.
All right. But Ms. Husband, your counsel is correct. All right. Yeah, these are all charges. And you were sentenced by Judge Alderson to complete the 173 days after the completion of probation. And it's created an issue. I do have a note indicating that you were in the Sault Ste. Marie County Jail. All right. And that you had an out date to that. So you were able to contact the court in relation to that. But it should come as no surprise to you that probation doesn't want to work with you, right? At least now. And I know you may be in a different place than you were then, okay? was 5 years ago and you're in a completely different place. And that's understandable, okay? But I'm gonna terminate the probation at this time because it just hasn't worked out. I'm gonna revoke any 7411 substance, controlled substance status, this is why we're having a private entity. I'm gonna terminate probation unsuccessfully. It sounds like, at least from your attorney's perspective, that you've been able to turn the corner on this. But there's a debt to pay, right? And you know that and you understand that. But I think you should be credited for the time that you've been able to make yourself to work on yourself. All right. I think that's important. So the sentence of the court is to spend the next 90 days in jail. And how we'll do this is I'll just indicate 90 days in jail. And then that'll remove any type of credit or anything else that we're talking about, because the 157 days comes out to about 5 or 6 months. And so we'll do the 90 days in jail, 3 months. Anything towards the sentence of the court, Ms. Wilson?
Nothing, people, thank you.
Mr. Lee?
Nothing further.
All right, Ms. Husband, good luck to you, okay, ma'am? All right, thank you. Should I wait on Ms. Herrera? Did you want to wait, and Porter Miller? I have a 5-minute civil hearing, and then we can.
I mean, at this point,
If you want to say no, just say no.
well, I don't necessarily want to bench warrant her at this point.
All right.
Because I think maybe she has given birth.
All right.
I would ask, Your Honor, it is a non-assaultive, non-serious.
So
misdemeanor. I would ask that
you want to reset it?
Reset it,
All
yeah.
right.
She brought her up to see and just returned her when she
All
came.
right.
Gotcha.
So let's call on the record docket 20-00913. That's people of the state of Michigan versus Antonia Herrera. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender on behalf of Ms. Herrera.
All right, this is the time set for a sentencing in the matter, and Ms. Herrera is not present, but there's some extenuating circumstances, and one of them being is that I have it in my notes that she was extremely pregnant at the time. So there may be a medical reason for her not being here. Ms. Wilson.
That is accurate, Your Honor. I do recall Ms. Herrera being pregnant, and by our math, it seems like maybe she's giving birth around this time. So obviously, if that's the case, we wouldn't expect her to be here. So I think at this point, it's prudent just reset this and give her another opportunity.
I think that's fair. I think that's a fair request. If Ms. Herrera doesn't show up next time, we got an issue. All right,
Yes.
but I think that we're going to reset this sentencing. Ms. Wicks, you wanted to make a record.
Yes, Your Honor, I believe Ms. Wilson actually made a excellent record. I would just echo the request for a reset. I would ask possibly for 2 weeks out, just if
Right.
she is, in the middle of some medical issues, giving her some time to get home and recover and with a new life that way. I would ask just for a date approximately 2 weeks out.
All right, so let's reset it and provide some time for,
We go to July 1st. Twins are no walk.
all right, July, tell me about it.
We both know.
July 1st, 2024
At 1:30.
at 1:30.
Thank you.
Thank you, Your Honor.
All right, so that's all for the record in 20-00913, and we'll wait to hear from Ms. Wicks, but I think that's a sufficient time for her to get.
Absolutely.
And then we have And then, oh, you're not in on that one, so we can let everybody in. That's the, we had an arraignment.
Yeah.
Oh, then you're still here on the motion.
Yep.
All right. So let me admit everybody in. Well, let's go ahead and call this. So we're on the record in docket 23-03570. That is people of the state of Michigan versus Sierra Porter Miller. It was the set, and this was, let's see, 6/10/2024. This was set for set for 1:30. It is now 2:42. It would appear that the defendant has failed to appear for their probation violation arraignment. And at this time, the court will issue a bench warrant and bond forfeiture, as we've had no contact with Sierra Porter Miller in regards to this case. And there's nobody by that name in the Zoom courtroom, physical courtroom, or actual courtroom. And so we'll issue a bench warrant and bond forfeiture for a fail to appear for her probation violation arraignment. And that's all for the record in 23-03570. And then we're on the record.
Just a second, I'm gonna
Ms. Herrera?
Yeah.
That's not the case.
Oh.
Ms. Herrera's the one that
Sorry.
I had them.
let me see if I. All right, Mr. Landman and Mr. Wasbury, you're here. Let me I'm going to pull up that case. We had a non-public hearing, and so I had to keep everybody kind of at bay on that. Let me pull that case up, and we'll call your case in just a second. All right, so we're on the record in docket 24-01593. That is the Autumn Ridge Townhomes versus Arian Davis. Will the parties please introduce themselves for the record? Mr. Land, I don't know who the plaintiff is anymore in this case. Representative of Autumn Ridge, Mr. Landman.
Your Honor, Daniel Landman, appearing as moving party wishing to, or moving attorney wishing to substitute in this case.
Good afternoon, Your Honor. Mark Wasbury on behalf of the plaintiff.
All right. This is the time set for a motion scheduled. And here's my understanding of, as I read the paperwork in the, by the way, this is a civil file, so I've got to go through and it's not like an actual paper file, which makes this either sound really progressive or not progressive at all. But it's my understanding that Mr. Wasbury, you've refused to sign the substitution of counsel. Is that correct?
That's correct.
All right. And and my understanding is this is Mr. Landman's request for a hearing that Mr. Wasbury is indicating that he's not substituting counsel, and mostly because he has work in the file under the previous owner of Autumn Ridge. Is that a fair statement, Mr. Wasbury?
That's correct. Additionally, Your Honor, this matter has been dismissed on a conditional dismissal, and The other side has no standing to bring this, this
So
matter.
your indication is that there's, once the conditional dismissal was met, there's, Mr. Landman can take over, because you're no longer involved anyway.
Well, I don't know that he represents Autumn Ridge. My position is they have no standing to bring this motion.
All right. And so, and Mr. Landman, my understanding of your position is that if Mr. Wasbury has a problem with the person who he's doing work with, he should sue the former owner and not the present owner, or at least hold the process up. Is that a fair statement?
Your Honor, we don't care, quite frankly, if Mr. Wasbury signs the substitution or not, as long as the court enters it. The fact of the matter is that if there is a violation of the terms of the conditional dismissal, Autumn Ridge wants to be able to enforce the provisions and obtain a judgment and an order of eviction. They don't want Mr. Wasbury to be the counsel of record, and it serves no purpose at this point for him to stay in the case. If a third party were trying to, if this motion is denied, we're going to simply file an appearance. And then a third party is going to be confused as to who the attorney of record is, because it's going to show our office as counsel of record. It's going to show Mr. Wasbury as counsel of record. If he has an issue, the issue is with his client, the former owner or former management company. Quite frankly, Your Honor, this is the changes in management, changes in ownership. When you're dealing with apartments or manufactured housing, it happens often. Our office has been substituted for numerous times in the 26 and a half years that I've worked for Swistack and Levine. It just happens. So here, there's new ownership or new management. They prefer our office to handle their cases going forward. We've tried to do things politely. We've been rebuffed. And so the only alternative at this point, given the court rule, is to seek a court order for us to substitute in. We have 6 motions pending, Your Honor. Your case is the first one out of the 6. We're in front of Judge Ward Wednesday, and we have 4 more with Judge Buchanan.
All right. Well, and Ms. Walker is the client, and she did sign the substitution of counsel, or she's the new owner of Autumn Ridge. Is that correct?
Well, it's part of the new management, I believe, Your Honor.
Okay. Mr. Wasser, anything you'd like to say before the court passes judgment in this?
No, Judge, I just think they should pay the $68 out of pocket. That's all I asked for. And I can't believe they won't even do that. So, but.
All right. Well, I'm going to sign the substitution of counsel. I'm not going to order any costs or attorney fees or costs of any kind. I'll e-sign that as it is in my bin to e-sign concerning this as substitution of counsel. And that's the ruling of the court. And I know you've got other hearings with Judge Ward and other judges, but I will sign the ex parte substitution of counsel, and we'll go from there.
Your Honor, will the court assign the substitution that was attached to the motion, or do we have to resubmit it?
I have it. I have the substitution of counsel in my sign bin, and I will sign that one, so you don't have to resubmit.
Thank you, Your Honor.
All right. Anything else for the record in 24-01593, Mr. Landman?
No, Your Honor.
Mr. Wasbury?
No, Judge.
All right. Thank you for everybody for your appearance. That's all for the record in 24-01593. Open for Miller. And Ms. Walker, you're all set. Thank you for your appearance today. Spill. saving everything. Just in case. You never know.
Yeah.
Who knows?
Yeah.
Must open this up twice. Yo, you have a question for me? You want to approach?
I'm trying to find an emergency stay on an eviction because when they issued the order of eviction, they then accidentally put the year the judgment was issued as 25 instead of 24. So he claims it makes it null and void.
That doesn't sound like a meritorious claim or no. Get it to that motion. I know.
I know you saw me. So I just.
I got bigger problems than the wrong date.
I just brought you everything just in case.
Thank you. Thank you.
Thank you.
You're welcome.
We're getting quick.
Oh my God. Was it a small plane?
All right, so we're going to call the last two cases and then we'll hear arguments. Mr. Professor Dodson, I didn't see you there. I saw you sitting next to Miss Williams, so lucky guy, right? Professor Moore, how are you? It's good to see you. We'll do two motions here, and so so you should watch what they're doing in these motions. One motion, yeah. I'm sorry, Abigail. I'm sorry, Miss Wicks. You guys are on notice.
I'm very good at arguing exact motions. I've argued against Mr. Stevens.
We're doing the first motion. We'll just do that's the one we like best, which is there's no argument. You're withdrawing the motion.
Yeah.
My favorite kind of motion. The second motion is an actual motion that the Judge Dragonchuck has actually done some work on this. This comes out of East Lansing, and you can hear that. And that'll actually, two arguments you've heard. I've already made some rulings on portions of it, but I thought that would be a good warm up for the arguments that you're seeing. All right, so let's call the one I like the most. Let's call Dominic Mims. So we're on the record in docket 22-03411. Will the parties please introduce themselves for the record? Miss Wilson.
Abigail Wilson for the people.
And Miss Wicks.
Taylor Wicks, Assistant Public Defender, on behalf of Mr. Mims. Mr. Mims' appearance has already been waived.
Thank you. It's my understanding today that the parties are not proceeding on the motion. Miss Wilson, I'll let you make a record.
Thank you, Your Honor. Yes, this case dates back to, I believe, 2022. As the court's aware, that's before my time at the prosecutor's office. For some reason, the last prosecutor thought that this case needed to be redacted. They never sought a protective order. I don't think it needs to be redacted, so I sent an unredacted version to Miss Wicks as she requested in her draft motion. So I don't think we have an issue anymore here.
Miss Wicks.
That is correct, Your Honor. I do believe at the time that this case was issued and first given to the public defender's office, that it was the regular practice of the Ingham County's office of the prosecutor to redact reports in every assaultive case. I think it was just one that simply got missed in the intervening months. This was something more or less to compel discovery. That discovery has reached me. I would withdraw the motion.
All right, thank you. So discovery is met in this matter. The motion's withdrawn. And anything else on the record? 22-03411, Miss Wilson.
Not for the people.
Miss Wicks.
No, thank you.
All right, thank you on that. That's my favorite kind of motion. Now, we're on the record in docket 24-00668. That is people of the state of Michigan versus Ebony Chapman. Will the parties please introduce themselves to the record, Ms. Wilson,
Abigail Wilson for the people.
and then Ms. Wicks.
Taylor Wicks, Assistant Public Defender, on behalf of Ms. Chapman, who is not present, I would ask that her appearance be waived as this is a legal argument.
And Ms. Wilson, you don't have any objection to me waiving the presence of Ms. Chapman on this legal motion?
No objection, Your Honor.
All right, and Ms. Wicks, this is the motion from the Public Defender's Office. I know it was previously argued and written by your office. I think Jonathan Foreman was here last time. Ms. Wicks, you may proceed.
Thank you, Your Honor. As you've stated, you do have some familiarity with these dog bite cases, and I won't belabor my brief or Judge Dragonchuk's brief, but since we do have an audience, I will at least give an overview of what's going on. What had happened is, both in this case and in multiple others, defendants stand charged under the Ingham County Animal Control Ordinance, which prohibits the owner of a dog from biting or attacking another person. The circuit court has held that the dog bite ordinance through the Ingham County Animal Control is invalid and unenforceable. This is because that the power given to the animal control is through the dog law of 1919, and it only grants limited authority to counties to pursue different charges. The dangerous animal would allow, if the dog had already been adjudicated to be vicious, that a bite charge could be issued at that point. However, we do not have that in this case. We simply have a singular action which would fall under the dog law from 1919 and not under the vicious animals from 1989. And so I would ask that the court dismiss this case, as the current case law, as far as Ingham County goes at least, does not allow the county the permission to criminalize a charge of this nature at this point. So I would ask for a dismissal in this matter.
Ms. Wilson.
Thank you, Your Honor. As has already been stated, that the court has kind of an idea of what it's going to do here, but I will make a brief record. Firstly, that the people are appealing Judge Dragonchuk's decision. As the court's aware, it's going to be a while before we get that decision. As to the argument here today, I have largely stolen my argument from our appellate attorney. I will just say that. First, I don't think that this ruling from Judge Dragonchuk is binding on the court here today. It is an unpublished decision out of the 30th Circuit Court. Unpublished decisions are not mandatory. They are persuasive, but they are not required. So as to the actual statute, the Constitution does allow courts to liberally construe law concerning counties. Under MCL 287.286A1, there is a mention of a dog bite as a basis for a summons or complaint under the dog bite law of 1919, which under the broad inference of the Constitution does allow for an inference that the city or the county ordinance can in fact enforce a dog bite ordinance in the county. So I do believe that the ordinance can be upheld, but again, I understand that the court's dealing with a persuasive ruling from the 30th Circuit that's currently on appeal. If the court's not willing to allow this case to proceed, I would request a dismissal without prejudice so that people can reissue should we prevail. Thank you.
Any response, Ms. Wicks?
No, Your Honor, I believe Judge Dragonchuk's and my brief specifically touch on some of those issues as well, and so I've read on that.
All right. As indicated previously, I've had the opportunity to read all the briefs, and I've read Judge Dragonchuk's opinion that comes out of East Lansing 54B District Court, in which he overruled the district court judge there, who indicated that there was a fair inference to be made. I don't know that the record was made because I've not read the record, but it indicated that the animal control had the authority to promulgate a statute, although it was not legislatively promulgated, and then enforce the statute. And that was part of Judge Dragonchuk's problem, was You can enforce the statute, but you don't have the authority to enforce the statute because legislatively you can't enact a statute to enforce. And based on her reading of the analysis, it's hard to argue with at this point in time. It's hard to argue with that analysis. And she indicates in her opinion that it's kind of like putting the cart before the horse, which makes a lot of sense. You have the authority to enforce it, but what are you enforcing? What you didn't have the authority to enforce, and that becomes a problem. And the court, Judge Dragic also indicated that without the authority to promulgate any legislation that didn't come directly from legislation, that creates this problem. And that's it goes directly to the dog bite ordinance that's been indicated. So at this time, based on Judge Dragic's opinion and the reasons stated for the record, I will dismiss without prejudice, since I know it's going to be up on appeal, which means that 6 or 8 months from now we'll have our opinion. But dismiss without prejudice. That means that the victim of the dog bite still has whatever civil remedies available to him, but criminally, as far as the criminal remedy, it's dismissed without prejudice pursuant to the Judge Dragic's persuasive circuit court opinion that is now on appeal to the Court of Appeals. So I'll dismiss without prejudice based on the record. And I think I don't know if Mr. Foreman did a nollie for that. Did he do a nollie for that?
It's a ticket.
Is it a ticket? Then if it's a ticket, then I have full authority over whatever ticket they wrote. Yes, it's a ticket.
Yeah, I have a ticket. Yeah.
All right. So I find for the public defender in regards to dismissing the ticket without prejudice, that ruling does not apply to the unlicensed dog that's still on.
Do we have dates set for the remainder of those?
I have. No, I just because we just put, so let's get a date for the 2 remaining unlicensed dog tickets, because I think we placed them both under.
Yeah.
Probably to set the dates today.
I think so.
Yeah. So we'll get new dates for 24-00673 and 24-00672, which would probably be a couple weeks out. Yeah.
June 24th at 9:30.
Say it again.
June 24th at 9:30.
So we'll set it for June 24th at 9:30 for dockets 24-00673 and 00672, and then 24-00668 will be dismissed without prejudice.
Thank you, Your Honor.
Anything else for the record on any of those files from the people?
Not for the people now.
Ms. Wicks.
Not from defense, thank you.
All right, we're all set on those files. Thank you. Thank you for reliving those events. I think that's it.
Well, I think technically we have William Hill still out there because he was out of custody. But we tried to argue that one.
Did we? That was this morning.
No, that was last week when Mr. Foreman was here. I'm just trying to figure out how many dog bites we still have out there. I think Mr. Hill's the last one.
I think Mr. Hill's
And
the
it
last
got,
one.
yeah, it got
Yeah, I
reset
got
for
it.
6/17.
Right.
so.
All right, you're all set.
Thank you, Your Honor.
Thank you. Yes, you may. How are you? Good to see you. Okay. And then Chris sent me a bunch of stuff too.
Okay.
All right. All right. They are, whether they like it or not, they are on live stream right now on YouTube. And so it's all being recorded. So if they go, I'll tell them this, if they go to my courtroom, they can see all their arguments and everything. Everything's been on the record. Oh, no. Let's do it. That'll be fine. Okay.
On what? What about it? Jaden?
He would.
Just because I thought it was.
The judge now.
Oh, really?
He's, yeah, I haven't heard things.
Minneapolis, was Hennepin County.
Okay. I just didn't know.
Yeah.
It was more so the calling a child over.
Yeah, yeah, no, I mean.
That's what, when you put both of them, I figured when you're doing both. But I was like, you didn't-
I'm kind of area.
Yeah, I mean, I don't honestly, but.
And I understand you
Yeah.
getting a buy into the
Yeah.
license, like I need it, like I get that, but I didn't know if it was
Well, I
like-
don't think, I think I needed anyway, because I didn't have.
And that's what. There's likely.
Did he come from
For.
That's who I think.
So then,
Describe.
are we gonna have a trial on Monday?
Is that what you were?
So if we've got a motion to exclude evidence coming for our trial that's set on Monday.
For the child abuse?
Yes, so I'm guessing then we're not running